You're listening to an African Elements top news story for June 24th, 2025. Please visit our website at africanelements.org for more daily news. Protecting free speech. NRA vs. Vullo's impact on Trump's agenda. The Supreme Court's reputation has faced scrutiny in recent years, with many observers questioning its impartiality. However, a recent unanimous decision, National Rifle Association vs. Vullo, offers a powerful reminder of the court's role in safeguarding fundamental rights. This ruling, which affirmed that government officials cannot coerce private parties to suppress disfavored views, is poised to significantly impact ongoing legal challenges against the Trump administration's actions. For communities of color, whose voices have often been marginalized or suppressed, this principle is especially vital. The fight for free speech and association is not new. It is a continuous struggle that has shaped the landscape of civil rights in America. From the pulpits of black churches to the protest lines, the ability to speak truth to power without fear of government reprisal has been a cornerstone of progress. The Vullo decision reinforces this critical protection, ensuring that the government cannot use its immense power to silence dissent or punish those who hold views it dislikes. This principle extends far beyond the specific parties involved in the case, offering a shield for all who seek to express themselves freely. In May 2024, the Supreme Court delivered a unanimous decision in National Rifle Association vs. Vullo, a ruling that has profound implications for First Amendment protections. The case centered on allegations by the National Rifle Association that Maria Vullo, the former superintendent of the New York Department of Financial Services, violated their First Amendment rights. The NRA claimed that Vullo coerced regulated entities, such as insurance companies and banks, to stop doing business with the organization. This alleged coercion aimed to suppress the NRA's advocacy for gun rights. The court, in an opinion written by Justice Sonia Sotomayor, found that the NRA plausibly alleged a First Amendment violation. The core principle reaffirmed by this decision is that government officials are prohibited from using their authority to pressure or force private individuals or entities to suppress speech or associations that the government dislikes. This ruling clarifies a crucial distinction. While government officials can express their views or engage in persuasion, they cannot cross the line into coercion, which effectively compels private parties to act as censors. This decision is expected to have significant impacts on the Trump administration's agenda and could help restore public faith in the Supreme Court due to its rare unanimous nature. For Black communities, who have historically faced attempts to silence their voices and movements, this reaffirmation of protection against government coercion is a powerful tool in the ongoing struggle for justice and equality. The Vullo decision did not emerge from a vacuum. It stands on the shoulders of established legal precedent. A key case that laid the groundwork for this principle is Bantam Books v. Sullivan, decided by the Supreme Court in 1963. In that case, a Rhode Island commission sent notices to book distributors labeling certain publications as objectionable and implicitly threatening legal action if distribution continued. The Supreme Court found that these actions, even without direct censorship, constituted an unconstitutional system of prior restraint. The relevance of Bantam Books to Vullo is clear. Both cases address situations where government officials use indirect pressure to achieve censorship, rather than outright legal prohibition. The threats in Bantam Books crossed the line because they effectively created a system of prior restraint by coercing the conduits of speech. The Vullo decision explicitly reaffirms this principle, emphasizing that government officials cannot attempt to coerce private parties into suppressing disfavored speech. This historical lineage underscores the long-standing commitment to protecting free expression from government overreach, a protection that has been critically important for marginalized groups seeking to tell their own stories and advocate for their rights without fear of reprisal. The Trump administration has engaged in various actions that appear to test the boundaries of First Amendment protections, particularly concerning federal funding and executive power. President Trump, in his second term, has issued executive orders that attempt to place conditions on how recipients of federal funding can speak and associate. These actions have led to significant legal challenges, with plaintiffs arguing that such conditions violate their First Amendment rights, echoing the concerns raised in Vullo. For example, environmental groups and municipalities have filed a lawsuit alleging that the Trump administration violated their free speech rights by targeting them over language used in grant documents. Terms such as equity and socioeconomic, often central to discussions about racial and social justice, were deemed controversial, and the administration allegedly tried to force these entities to use different language. Harvard University has also filed a lawsuit contending that a federal funding freeze threatens its First Amendment rights. Furthermore, Protect Democracy is challenging the administration's termination of $400 million in federal funding for public health research to Columbia University. This lawsuit alleges that the administration is using funding cuts as a tool to coerce the private institution into adopting restrictive speech codes and allowing government control over teaching and learning, violating the First Amendment and other constitutional provisions. These actions, which target a wide range of entities from law firms to media companies, highlight a pattern of attempting to punish or suppress speech disfavored by the administration. For Black communities, the targeting of terms like equity is particularly concerning, as these concepts are fundamental to addressing systemic inequalities and advancing racial justice. Beyond the direct suppression of speech, the First Amendment also protects the crucial right to freedom of association. This right allows individuals to join with others to pursue common interests, express views, or engage in collective action without undue government interference. It means the government cannot compel individuals to join or refrain from joining certain groups, nor can it punish individuals or groups for their associations, especially when those associations are for expressive purposes. Attempts by the Trump administration to punish third parties for their association with entities like Harvard constitute obvious violations of this freedom. Another foundational principle in this battle comes from West Virginia State Board of Education versus Barnett. In this landmark case, Supreme Court Justice Robert Jackson articulated a powerful defense of intellectual freedom. If there is any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion or force citizens to confess by word or act their faith therein. To prescribe orthodoxy means to dictate what people must believe or say. Justice Jackson's experience prosecuting Nazi leaders at the Nuremberg trials deeply informed this principle, underscoring the vital importance of protecting free speech from government coercion. The Trump administration's efforts to dictate orthodoxy at universities, for instance, should not withstand legal challenge under the First Amendment, aligning with the principles of Barnett. For African Americans, whose history is replete with struggles against prescribed orthodoxies and forced conformity, these protections are not merely legal abstractions, but essential safeguards for cultural identity, political expression, and the pursuit of self-determination. The Vullo decision is likely to play a central role in future Supreme Court considerations of challenges to the Trump administration's actions, particularly those involving First Amendment issues. Legal experts anticipate that the court will consider cases involving executive orders against law firms, attempts to cut government grants and research funding from universities, and potential moves to strip nonprofits of their tax-exempt status. Copyright African Elements.